Good afternoon to those of you in the Eastern time zone, and good morning to any of you who are farther west. We are delighted to have you with us for our webinar, a discussion on the Electoral College with Ned Foley and Jesse Wegman, sponsored by the Election Law Program at The Ohio State University Moritz College of Law. I am Steve Huffner. I'm a faculty member at the Moritz College of Law and a founding member of our Election Law Program, and I will be the moderator of this event. We are privileged to have with us Jesse Wegman, a member of the New York Times editorial board, where he writes on the Supreme Court and legal affairs. Jesse is the author of Let the People Pick the President, a just published book that came out just last month from St. Martin Press. Before joining the New York Times editorial board in 2013, Jesse held a variety of positions at Newsweek, the Daily Beast, Reuters, the New York Observer, and National Public Radio. He also holds a law degree, graduating from New York University School of Law in 2005, and then clerking at the U.S. District Court for the Southern District of New York before returning to his journalistic roots. We are also pleased to have with us today my Ohio State colleague, Ned Foley, who holds the Ebersold Chair in Constitutional Law here at the Ohio State University Moritz College of Law. Ned is the author of Presidential Elections and Majority Rule, also published earlier this calendar year by Oxford University Press. Ned is one of the country's foremost experts on election law and process, including questions of resolving disputed elections. His previous work includes his 2016 book, Ballot Battles, as well as service as the reporter for the American Law Institute's recent project to develop principles of election administration. Ned is also the director of our election law program here at the Moritz College of Law. So as I noted, Jesse and Ned each have brand new books, both of them offering reform proposals for the Electoral College. And before the webinar concludes today, we will share with you links to the publishers of both of these books where you can find out more information about them. The Electoral College, of course, is the constitutionally specified mechanism for choosing our president every 4 years, a process that has long been the subject of criticism and a variety of reform proposals. In just a minute, I'm going to ask Jesse first to give us an overview of his particular argument and his particular Electoral College reform proposal. And then we will invite Ned to likewise give us an overview of his quite different Electoral College reform proposal. From there on, we will have the chance to pose questions to each of them, including to ask them to reflect on and respond to the others. So we will encourage you to also submit questions for Jesse or Ned using the Q&A feature of this webinar. To ask a question, hover your cursor near the bottom of your Zoom window to display the Zoom taskbar. From there, click on the Q&A to open the Q&A box, and then type your question in the box and click send. And please note that for today's webinar, the separate Zoom chat feature is available if you have a logistical concern or technical question for the host, but use the Q&A feature to raise questions for our guests today. So with that, I will invite Jesse to get us started today. Jesse, please.
Thanks so much, Steve. It's really a pleasure to be here with you and with Ned. I was saying to Ned the other day that I had a 6-week nationwide book tour planned to promote this book. And of course, all of the events collapsed. And I was happy to see that this event with OSU and with Ned and you is the one event that's actually coming off at almost exactly the time and date that we set it for. So in this time of great uncertainty and chaos, it's nice to have something going almost exactly as planned. So, you know, I started working on this book a few years ago in a different world. And you know, I think part of what both surprised and excited me as I was working on it was how much of a tradition of critique and reform-minded thinking I was joining. Obviously, I knew I wasn't the first person to criticize the Electoral College, but what shocked me was just how many efforts there have been to either amend or abolish it over the nation's history. There have been more than 700 attempts in Congress, more than 700 to amend or abolish the way we pick our president since the founding. That is far more than for any other provision of the Constitution. That should just tell you what a contested provision this is and has been from the beginning. Some people say, oh, you're a New York Times editorial board. Of course you want to get rid of the Electoral College. You know, people from the left to the right to the center have been challenging this system from the start. And I think there's really a couple reasons for that. One is the understanding, which the founders themselves had, which is how this violates some very fundamental ideals we have about how a democracy works. One of those is what we today call political equality, the ideal of one person, one vote, the idea that all votes matter equally. Obviously, when the founders wrote the Constitution and created the Electoral College, that was not literally true. Very few people could vote. You know, slaves could vote, women couldn't vote, Native Americans couldn't vote, you know, poorer whites couldn't vote. But that idea was threaded through a lot of the debates at the Constitutional Convention in 1787. Several of the framers actually were quite emphatic about it as an ideal. The other one is majority rule, the idea that the person who wins the most votes wins the election. And that is something that the framers themselves talked about being an essential component of a republic. That majority rule is the essence of a Republican government. And that is, in fact, how we run all elections in our country, except for this one, the biggest and most important of all. So I think the realization that the system that the founders cobbled together in the last days of the Constitutional Convention in Philadelphia violates those tenets of what we now, I think, all agree are central to a modern democracy, has been driving a lot of the reform efforts. And then the other one, I think, is a more practical one. Those are the principles, right? And then the more practical objections really come from people seeing how this system plays out on the ground every 4 years. And, you know, one of the things I hear most often when I debate the Electoral College with people is, well, you know, if you got rid of the Electoral College, first, it's you know, this is what the framers designed. It was brilliant design to keep the cities from dominating the elections and to protect the small states. And you know, we're a republic, not a democracy. Those kinds of things, right? There's just a lot of fundamental misunderstandings there, both about what the framers believed and what they built the college to do, but also about how it operates today. So just to very briefly address those most common critiques, and we'll get back into this again and again, I think, over the course of this discussion. The big cities, first of all, there were no big cities at the founding. So the framers were not thinking of big cities and protecting the rural areas of the country from big cities when they instituted the Electoral College. And also, big cities today couldn't dominate an election if they tried. Just to use one example, in 2004, George W. Bush beat John Kerry by 3 million votes nationwide in the popular vote. And he didn't win any of the big cities. The big cities all went for the Democrats. So it's not at all difficult for a candidate to win the popular vote and win the Electoral College without winning big cities. And then this other kind of corollary idea of small states being protected. This really gets to the heart of, I think, something about the Electoral College, which we're going to get into more here, but which I think people really need to understand at the outset, which is, you know, Steve, in your introduction, you said the Electoral College is the constitutionally mandated way that we elect our president. That's true, but let's just qualify that somewhat. Certain parts of the Electoral College are constitutionally mandated. The parts that we know the best and the parts that actually affect our elections most, affect them the most, are not in the Constitution. And the biggest one of those is what's known as this winner-take-all rule, the statewide winner-take-all rule, which is purely a state-by-state decision that lawmakers in each state decide to adopt this rule. They've all had it basically since the middle of the 19th century. Two states today don't use it, Maine and Nebraska, but the other 48 do. And there's no constitutional provision for that. The founders who saw it taking shape in the early years of the country's life were actually very, very concerned about it. And James Madison even tried to propose a constitutional amendment banning the practice of winner-take-all in each state. But that system, the winner-take-all rule, where the red and blue map that we see that are on the cover of Ned's book and the cover of my book, that's just an artifact of the winner-take-all rule, which has no constitutional basis at all. And that's really what I think distorts the way the Electoral College reflects the popular will of American people. So small states are currently ignored under our system of government, under our system of electing the president, because they are not, under the winner-take-all rule, the only states that really matter to the outcome of the election are what are called battleground states. And small states are not battleground states. They are safe states for either the Republican candidate or the Democrat. Same is true for big states. It's really this very small handful of battleground states. We know which they are. Ohio used to be one of them. It's sort of trending away from being one now. But we know they're Michigan, Wisconsin, Pennsylvania, Florida, Arizona, North Carolina. This year, half a dozen, give or take, every year. And really, the candidates focus all of their attention and all of their money and all of their campaigning in just those states, to the exclusion of everyone else in the country and to the exclusion of the interests of everyone else in the country. And I think that's really the most distorting feature of our electoral college system as it operates today. And I think it's the one that I am advocating getting passed. So whether it's getting to a national popular vote through a constitutional amendment or through the National Popular Vote Interstate Compact, which I'll talk about later in this discussion. I'm sort of agnostic on that, but I really think that is the true harm that is done to the country, is this focus on fewer than 20% of Americans, to decide a national election. And in some cases, far fewer than that. You could say the 2016 election was decided by about 77,000 votes across 3 states in the upper Midwest, when 140 million people were casting ballots. That to me is no way to run a nationwide election in a modern 21st century democracy. And it's no way to govern the country when you have to win by that few votes, when you can win with that small sliver of the electorate. So that's really kind of like the quick layout. My book covers the history of the college. It goes up through all the, many of the efforts to amend it, as well as an attempt in the late 1960s that came closer than we've ever come to abolishing the college, which we can talk about as well. And then it gets into some of these misunderstandings, misconceptions, and even outright myths that I think a lot of people still hold on to about the college. But that said, I'm happy to answer questions and talk about any element of this, and I'm eager to hear Ned speak on this as well.
Great, thanks, Jesse. Let me ask you just one immediate follow-up now, if I could, and then get into many more, I'm sure, later. But you observed not only that there have been, some 700 attempts to amend or do away with the Electoral College, but also that in recent years, there's often been some sort of sense that the Electoral College reform proposals have been driven heavily by those that are more on the left of our ideological spectrum. Now, you made reference in your brief overview to the rural versus urban dynamic, and we're beginning to explain how that was not such a watershed difference for purposes of the Electoral College and presidential elections. But I'm interested in putting a little more specific question to you of whether you think today the existence of the Electoral College tends to favor Democrats or Republicans in any sort of systematic or consistent way today?
That's a great question. To break it into the 2 pieces I think you asked it in. First, of course, the calls for reform in the last 2 decades have come more from the Democratic side. The Democrats have lost 2 elections of the last 5, even though their candidate won the popular vote nationwide. All efforts to reform the college over history, or let's say, Ned could probably correct me here, but the vast majority have been not out of some higher principle, but because people thought it hurt their party, it hurt their side. Republicans are defending it not because Republicans believe in sort of deeper constitutional principles than Democrats, it's because they won the elections. You know, I mean, just the simplest way to illustrate this is to look at Donald Trump and his tweet on election night of 2012. He tweeted, the Electoral College is a disaster for a democracy. Donald Trump tweeted that on election night 2012. Why did he do that? Is because in the early evening, when the returns were just starting to roll in, it looked possible that Mitt Romney, the Republican candidate, was going to win the popular vote and lose the Electoral College to Barack Obama. The hint alone that that might happen was enough for Donald Trump, who is a Republican, to express this rage on Twitter. This is his early Twitter rages. A few minutes later, he tweeted, "More votes equals a loss? Revolution." He deleted that tweet, but I think it really gets to the heart of people's fundamental sense of unfairness about how the Electoral College operates. So the fact that Democrats are the ones now who are more upset about it, I don't think reveals much other than that they're the ones who've been burned. I think if you had had 60,000 votes in Ohio switch in 2004, John Kerry would have become president despite losing the popular vote by 3 million votes to George W. Bush. We would have had the Electoral College would have been out the door the next day because then it would have happened to both parties in a 4-year span. With regard to the second part of your question, which is, does the college as it operates today actually have a systematic bias toward one party or the other? I think the answer is pretty clearly no. I think what I can say to qualify that somewhat is, after any election, you can look back and say, yes, there was an Electoral College bias in favor of one party or the other. In 2016, that bias was clearly in favor of the Republicans. In 2020, probably it will be in favor of the Republicans too. But you can't say this in any, if you pull back the lens and look at any wider time window, you really can't say that. You look at over, I think, an 80-year span, and it's really impossible to say that the college systematically is biased in favor of either party. It changes because of conditions on the ground. It changes because of how the parties campaign and where they're located and where their strengths are. And I think, so I think it's really clear that while Republicans right now are more likely to win a split election, I think that is very much due to contingent factors that we see on the ground today. I think if the party changed, you know, it's a very Trump-driven party today, and that taps into certain elements of the Electoral College that are beneficial to Republicans. But I also think that could very quickly change if, say, Texas becomes a Democratic majority state, or Georgia, which both could happen in the next decade. So I really think we should be careful before we make any broader assumptions about bias in the Electoral College towards one party or the other.
Great, thank you, Jesse. Well, so let me now turn some time over to Ned for him to give us a bit of an overview of his perspective and his new book. Ned?
Great, thanks, Steve, and thanks, Jesse. This is great to have this conversation. There's a lot of common ground, I think, between Jesse's perspectives and mine. There are some differences, so I'll try to delineate some of that going forward, and then we can get into the details. First is, I shared Jesse's view that the best thing would be is if we could get a constitutional amendment that replaced the Electoral College with a national popular vote that was based on genuine majority rule. So that would be desirable. But for the reasons that Jesse details, it's been impossible to get a constitutional amendment to do that or anything else since the 12th Amendment, which is our one big constitutional amendment to change the Electoral College. So part of my goal in my book was to think about second best solutions in the absence of a constitutional amendment, and also, more importantly, was to figure out what our existing Electoral College is designed to do, and is it working according to its own premises? Because what struck me most in the returns from 2016 was not the discrepancy between the national popular vote and the Electoral College, which is true, happened, as Jesse said, and happened back in 2000. But, and again, I want a constitutional amendment to change that. But I think it is given that the Electoral College is not designed to achieve a national popular vote. It's designed to aggregate, different states, what they do in appointing their electors into a national total. So, but what struck me as potentially anomalous with this commitment to majority rule that Jesse is correct is in the system was the fact that Trump, as a candidate, was able to win his Electoral College victory by winning the battleground states that Jesse mentioned without majority support. So in all 6 states that Jesse mentioned, Michigan, Wisconsin, Pennsylvania, Florida, North Carolina, and Arizona, the battlegrounds, Trump was under 50% in the popular vote in those states. And yet, as Jesse said, winner take all allowed him to get all of the electoral votes from those states. So Florida has 29 electoral votes. Trump is getting all 29 with only about 48% of the popular vote, which is a little strange, right? He's capturing all the marbles. There are more ballots cast against him, if you will. They're not counted for him, and yet he's getting all of the electoral votes. And so he cannot reach an Electoral College majority, and therefore can't get an Electoral College victory without these sub 50% wins in the battleground. So there seemed this odd disconnect between what the Constitution says about majority rule and operationally what was happening. And I wanted to try to figure that out, because sort of the question that I asked myself was, what would the authors of the Electoral College think of Trump's victory, not as Trump's ideology and as a candidate, but just the way he won the system. And I didn't know the answer. I thought this was an interesting research project, and I jumped into the research, and I was sort of amazed at what I found. It's kind of excited because it was a story that I did not know, never had been taught to me, and I don't think is well understood in our country. And it has to do with what our Electoral College is, how we kind of abandon its own premises, and now what we could do to fix it, short of a constitutional amendment, which is so hard to do. So I'll quickly go through those 3 parts, because the book has those 3 components to it. But I do want to say one thing about the nature of majority rule, which we've already been talking about and is part of the title of my book. Jesse defined it as the person who wins the most votes. And that is often colloquially how we talk about it as a society. But that's where, as law professors, get in trouble for our persticketiness and our technicalities, because an important, at least part of my book and my argument, is that there's a fundamental distinction between majority rule, majority winners, and so-called plurality winners, or plurality rule, if that's a terminology. Because technically, what Jesse defined as majority rule is how we, at least as law professors, call plurality rule. So, and this only makes a difference when there's more than 2 candidates. And that indeed is the major theme of my book. If you want one big picture takeaway, is our Electoral College was designed for 2-party competition, us versus them. We'll go into details on that. But the world that we live in now allows for multi-party competition. And in fact, I'm glad we're having our discussion this week, because earlier this week, Justin Amash, the US representative, member of Congress from Michigan, who used to be a Republican, but is a never-Trumper, supported impeachment and is now an independent, he kind of announced that he is looking closely at a so-called independent or third-party bid. That is not something our system is designed to handle. That's part of what my book shows. It really kind of messes it up, because we think we have a 2-party system. That's sort of how we operate. But in fact, we don't. We have the worst of both worlds, because we have a multi-party system that is a dysfunctional multi-party system, at least with respect to presidential elections. And it goes to this distinction between majority rule and pluralities, because again, if you only have 2 candidates, the candidate with the most votes definitely has a majority. But if you have 3 or more candidates, it's possible that the candidate with the most votes doesn't have a majority. And that's exactly what Donald Trump achieved in 2016 in the 6 battlegrounds that we're talking about. And that's because Jill Stein was on the ballot as the Green Party candidate, and even more importantly, Gary Johnson was on the ballot as the Libertarian candidate. And although they weren't on the stage in the debates, and although most Americans thought this 2016 was just an election between Clinton and Trump, in fact, Gary Johnson is incredibly decisive in the battlegrounds because, what his support might have done if it had just been a head-to-head race, might have been outcome determinative. Again, we'll get into those details. And I don't want to make my overview too much, but just very quickly, point number one, which I did not know ahead of time, was, I guess I technically knew that the 12th Amendment is operative about what our Electoral College is, but I did not understand the significance between the difference between the 12th Amendment and the original Electoral College that came before it, that was part of the Constitutional Convention in Philadelphia in 1787. They are very different. And the way to understand this is that the original system was designed to achieve consensus, a winner like George Washington who would rise above political parties, because the delegates in Philadelphia hoped that they would create a political system without political parties. Well, that completely fell apart at the start. And in fact, they got two-party competition. They got the Federalists of Alexander Hamilton and John Adams on one side, and the other party, which has gone by different names, I like to call them the Jeffersonians because Jefferson was their main person, but James Madison was part of that. And again, the founders who wrote the Federalist Papers together, Madison and Hamilton, split by 1792, and they're at each other's throats. And they have a partisan competition that is as intense as we have today. And they have this disaster election of 1800, which we could talk about if we need to. But in any event, they recreate the Electoral College and the 12th Amendment. And now what is in mind is us versus them, but it should be us, meaning the Jeffersonians, if we indeed have a majority mandate. We should get the presidency if our guy has majority support instead of the other team. But the majority rule that they have in mind is not simple national count all the votes nationwide. They still believe it has to be a majority rule for a federal system. So what they are doing is, after the experience of the 4 elections that they've lived through, the first 4, they are rebuilding the Constitution with these 2 pillars of Republican government and a federal constitution for the United States, a union of states. And they say the way to put these together is by something that they have in mind of compound majority rule. So a president should win the Electoral College, a majority of electoral votes, by amassing majority support in enough states to get to that federal or compound majority. They're very clear about this in the debates on the 12th Amendment, which are much more extensive and robust than what had happened in the Philadelphia Convention. So they had this vision in mind, but then we as a country abandoned that vision subsequently, and we could explore some of the details, but Jesse was absolutely right that the states, which were given the power to figure out their own method of appointing electors, they kind of abused this power from the perspective of what they were supposed to do. When the Jeffersonians wrote the 12th Amendment, they thought states would use that power to award their own home electors to whichever candidate or party had majority support within that state, because that's how the states had been operating up until that point. But to make a long story short, along comes Andrew Jackson in the 1820s, and things kind of fall apart, and they move to winner take all, but it's plurality winner take all, not majority winner take all. And that is okay, again, as long as they're just 2 parties. But it's when you get the emergence of third parties that the system goes haywire. It does so in 1844 in what is a very significant election that I never learned about in any history class in high school or college, and we can come back to it in Q&A because it illustrates the kind of problems that things go wrong. The most prominent historian of that period, a guy named Sean Wilentz at Princeton, has compared that election to 2000 because there was a third-party candidate there who he calls the Ralph Nader of 1844, and we could explain that if we think that's valuable. But 2000 is another example where Ralph Nader, as a third-party candidate, messes up the competition between the 2 main candidates. We could talk about Ross Perot in 1992. My point is not a partisan point. To go to Steve's question, my point is that both parties could be hurt by the emergence of a third candidate. It depends upon the triangulation. It's how the three interact with each other. That could be true again of Justin Amash. He could hurt Trump, he could hurt Biden. The whole point is he shouldn't hurt the system. The system should be able to handle his presence, but it can't. And the voters as a whole could get hurt, and majority rule could get hurt. So what do we do about it? We actually utilize the feature that Jesse referred to, the fact that states can choose their method of appointing electors. And if states insisted upon majority rule, they could accomplish the Jeffersonian vision by making sure that each state only awarded electoral votes to a genuine majority winner within the state. And they could do that by a variety of methods. They could do what many states did originally, at least some states, a significant number of states did, which were to have old-fashioned runoffs. If you don't get a majority in round one, 2 weeks later, the top two candidates go to a runoff. A little complicated, costs money, maybe not the best system, but it would comply with majority rule. A better idea, Maine just adopted for its presidential election for this year, is something called ranked choice voting, or sometimes called instant runoff voting, because it produces a majority winner instantly when you have more than two candidates on the ballot, like a Justin Amash or what have you. So, you know, the reform that I would really urge states to do, especially the battleground states, is to adopt ranked choice voting, instant runoff voting, because then the presence of a third or fourth candidate can't mess things up. If they're really going to catch fire and take hold, they, like Teddy Roosevelt did in 1912, if we want to use that example, your third candidate may actually leapfrog over one or the others of the major parties. But if they end up being still kind of low-grade candidates like Jill Stein or Gary Johnson, they're on the ballot, but they don't make any difference if you have ranked choice voting. And if ranked choice voting had been used in the pivotal states in 2016, we don't know for sure, but it's kind of interesting to think about. If Michigan, Wisconsin, and Pennsylvania had used some form of runoff method, either a regular runoff or an instant runoff method, I don't know that Trump would have won those states. Maybe, but maybe Hillary Clinton would have won the runoffs there. That's why we need, I think, the reform that gets us genuine majority rule in the states, so that the Electoral College winner is a genuine compound majority rule winner, according to the Jeffersonian vision of the 12th Amendment. So that's the essence of my argument.
Terrific. Thanks, Ned. And I'll just say that although the 2016 election is the freshest one in all of our minds, and one we're often interested in thinking about how these kinds of features might have played out differently, I know, Ned, that your book demonstrates that with the few other cases in which the Electoral College has misfired from the Jeffersonian perspective, it's easier to say with respect to some of those earlier elections that had the states required an actual majority support before they would award all of their electoral votes to a given candidate, some of those earlier elections pretty clearly would have been different. The results would have been different. 2016, you said it's not as clear, but I know your book says some of the earlier ones were clear.
Yeah, and if you want me to just jump in real quick on that, that's why I mentioned this election of 1844, because again, you know, none of us, at least I didn't learn about it in high school, but some historians, again, think it precipitated or set us on the road to the Civil War. It was that consequential. So that was James Polk was the Democrat, and Henry Clay was so-called Whig candidate. And Abraham Lincoln that year was a Whig before he became a Republican, and was very much supportive of Henry Clay. And the fight was over slavery and the expansion of the country west. And the Polk was the candidate. You may have heard of the phrase manifest destiny. That's what James Polk was. He thought it was the moral right of the United States to conquer territory out west, Texas, California, whatnot, even if those territories didn't want to be conquered. It was very imperialistic. And it doesn't matter what Mexico wants or whatever, we're taking Texas by force if necessary. And he went to war. He won that election. But he won it in this misfiring way, as you described. And he wanted to expand for the sake of slavery. He was unabashedly pro-slavery. Henry Clay, on the other hand, was anti-slavery, thought that slavery would eventually die again, very much like Abraham Lincoln. That was the position in 1844. Henry Clay said, if America expands west, it should do so peacefully. We're not a nation of conquerors or conquest. We're a democracy. We're peaceful. We'll negotiate for more territory. We won't take it by force. That was the debate in 1844. And like Lincoln, Clay thought that slavery would eventually be economically not successful and morally repugnant and would eventually disappear. But he wasn't immediate abolitionist, neither was Lincoln. And that was the third party candidate. There was a Liberty Party, an abolitionist party, and its candidate was a guy named James Birney, not Bernie Sanders, but James Birney. And he was, again, the Ralph Nader of that year. He was clearly outflanking on the left, if you will, Clay. He was saying Clay wasn't pure on slavery because it was too go slow. We want abolition immediately. Kind of a pure position. It was a morally courageous position, but in a world of two-party competition, it wasn't where it was going to be. And Lincoln kept pleading with voters, if you don't like slavery, vote for Clay, because that's your only realistic choice. You know, yes, you may agree with Bernie as a matter of moral courage, but in our system, Clay is, if you hate slavery, you got to vote for Clay. Well, what happened was in the pivotal state, it was New York that year, Polk wins a plurality, not a majority. And it's very clear that the anti-slavery vote is split. Clay gets, you know, most of it, almost all of it, but Bernie gets just a slice of it that brings Clay below the majority threshold. It's clear if there would have been a runoff, Clay would beat Polk in New York. Clay would win, and the course of history would be different, maybe no Civil War. But Polk wins a plurality, and with that, New York and then the whole Electoral College. So that was the first real breakdown of the system. And in fact, the newspapers of the day talk about Polk as a mistaken winner, an accidental candidate, because it wasn't how the system was supposed to work. So, you know, and then, you know, we could talk about others, but it had tragic consequences that the system went awry that way.
So thanks for putting more specificity on the way in which these implications or these features can have implications that matter. Now, you've both talked about the importance of majority rule, as well as some of the problematic natures of winner-take-all systems that, in fact, are how things are done in most places. I want to put back to Jesse a question of, to what extent the winner-take-all problem persists even under something like the National Popular Vote plan and that compact, in the sense that if there is no single candidate in a national popular vote who achieves a majority of the total popular vote because of the existence of third-party candidates, as Ned has been describing, are we then just stuck with still giving the plurality winner everything, in the sense of winner take all now means the president is elected by a plurality, not a majority?
We've done it 1 in 3 times since the beginning of the nation's birth. 15 of our 45 presidents have been elected without a majority of the popular vote. I don't think the American people are losing sleep at night over the fact that their president won 48% or 46% of the vote. On top of that, of course, we've had 5 presidents take office who did not win the popular vote at all. If the American people and can tolerate, and the American Republic can survive, both presidents who technically lose the popular vote and presidents who might win it but without a majority, I think we're going to be okay with a president winning a popular vote election without a majority. That said, I do understand the concerns about, you know, if you open it up to a popular vote election, you take away the disincentive, or you add the incentive for third-party candidates to get in, because right now, under a winner-take-all system, there's no point for most third-party candidates to run, right, except as vanity projects or people who have more money than God. So someone like Ross Perot or Tom Steyer might try to get in there and you know, monkey with the system and basically get as many votes as they can. But really, you know, when there's a popular vote election, you say, okay, well, that person could win, you know, enough votes to draw down the plurality winner, as I think Ned rightly is distinguishing between majority and plurality here. But say draw down that winner into the, let's say, into the 30s, into the low 30s. I think then you start to run into questions of democratic legitimacy. But you know, I'm really not, I'm not concerned about that for a couple reasons. One is no system no electoral system is perfect, right? We're choosing here among a lot of different competing interests. That's a problem I'd be happy to have in exchange for treating everybody's vote equally and making all voters count and having the person who gets the most votes win. I think those are just such fundamental tenets of a democratic system that I want to get there first, and then we can deal with the other problems. But the other thing is, you know, look at how states actually run elections now, and look at what actually happens in elections. There's something in political science called Duverges Law, which I think Ned could probably speak to with more eloquence than I could. But the basic idea is that plurality elections actually promote the two-party system. So when you have an election between candidates, or even among a few candidates, what ends up happening is the two parties really distinguish themselves from everybody else near the end, and that the winner almost always wins near a majority or more than a majority. And you can see this in state governor elections over the last 50 years. You look at those elections, the vast majority of them, the candidate who won more than 45% of the vote, and something in like 90% of them still, the candidate won a majority, an outright majority, over 50%. So if you were going to see this effect that a lot of people have said they're concerned about, which is a winner who actually only wins 25 or 30% of the vote, you would expect to see it now in state gubernatorial elections, which are the closest proxy we have right now to a national popular vote, right? Candidates who are running to win their jurisdiction by the most votes possible, and you don't see it happening. So I'm not really, that's a concern, that's sort of, to me, a second order concern, and it's among the many that are brought up as ways to push back against the idea of a popular vote election, when I think the popular vote election is the baseline that we should be starting from.
Great, thanks, Jesse. So let me now begin to start posing to each of you questions that are coming in from our audience, and also at this point invite others. I mean, I already have several that have come in through the question and answer feature in the webinar. But let me first ask both of you to talk a little more about the possibility of having states use proportional systems rather than runoffs, as Ned suggested, or rather than a national popular vote system, as Jesse has suggested. Instead, if states were to award their electoral votes based on the state proportional share, how would you each feel about that?
You want me to start, Ned, or do you want to take that?
Go for it, Jesse.
So, you know, this has been a proposal throughout many decades of our history to go to a proportional system. Once again, just to lay out clearly, states have total authority to decide how to award their electors. The fact that states, 48 of the 50 states now do winner take all, is purely up to them, right? They could do it however they want. Proportional is another method of how to do it. And under this system that, as has been discussed in recent, over the decades, what they would do is they would allocate their electors based on the proportion of the statewide popular vote. Now let's just to be clear at the outset, each state gets a number of electors equal to its representation in Congress. So that means 2 for its senators, and then however many for its House members. All right, so Ned said Florida has 29, California has 55 because it has 53 House members and 2 senators. How would you break those up, right? Right now, 55 California electors go to one side or the other. 29 Florida electors go to one side or the other. Under a proportional system, the idea is that you would divide it based on the popular vote proportions that the candidates won. If the Democrat won 60% of the popular vote and the Republican won 40%, the Democrat would get 60% of the electors and the Republican would get 40%. It sounds great. It has a kind of intuitive appeal, right? Well, why don't we just reflect the will of the people more accurately? There is an appeal to it. It also is deeply flawed, and I'll tell you a few reasons why. First of all, without amending the Constitution, there's only one type of proportional allocation or proportional awarding of electors you can do, and that's what's called whole number proportional allocation. And that is, electors are people, they're human beings. In the Constitution, human beings cannot be carved up into fractions, so they have to be allocated in whole numbers. So in a state like California with so many electors, 55, right, you could get fairly close to representing accurately the will of the popular vote. Because you can divide that pretty evenly. I think Republicans would probably win roughly 20 of the state's electors. Democrats would win about 35. There's a lot of Republicans in California, by the way, so that might be higher than people think because they always see California as this deep blue state. But really, there's millions and millions of Republicans in California who are completely ignored under the winner-take-all system. They're basically erased from the presidential vote. The problem becomes more serious when you look at smaller states, and it becomes a lot harder to divide those states' electoral votes into numbers that actually reflect the popular vote. The most extreme example, of course, are the small states which have 3 electoral votes. That's the fewest that you can have, is 3, 2 for your senators and 1 House member. Let's say a state like Wyoming, which has 3 electoral votes, splits in the popular vote 51 to 49. How do you represent that with 3 electors, right? You either got 3 to 0 or 2 to 1. Neither of those is reflective of the popular vote. And when you start to replicate that across the nation, you start to see the same distortions that you see right now, which is a popular vote that is not reflected in the Electoral College vote, and a president who can become elected without winning the most votes in the country. There's another way to do proportional voting and proportional awarding, which is what's called fractional proportional allocation. And in that way, you could carve up electoral votes down to, in tenths, you could go as many decimals out as you like. And then you could really almost exactly represent the state's popular vote, with the exception of each state having its 2 senators. So that does distort things a little bit. Smaller states would get comparatively more influence. The problem with the fractional awarding of electoral votes is you can't do that without amending the Constitution. As I just said, the Constitution makes people are electors. You would have to go into the Constitution and say the states get electoral votes, but those don't correspond to things, and the states can do what they want with their electoral votes. That would get us much closer to what a popular vote election would look like, but you would still require a constitutional amendment. And if the whole premise of this conversation is a constitutional amendment is unlikely to happen because they're very, very hard to get done, I think you'd be running into the same problems there.
Thanks, Jesse. Ned?
Yeah, just a couple of things. As a practical matter, I think states like Florida or California aren't going to want to divide up their clout. I mean, in the early years of the Republic, states experimented with divvying up their electoral votes, and the bigger states back then thought, hey, we'd like all of our electors to go to one side or the other. So again, and without a constitutional amendment, I think we're stuck with that hydraulic pressure. But I think it is a huge difference whether or not all 29 go to a majority winner versus a plurality winner. So that's one point there. If I could go back just real quick to a couple of things that Jesse said earlier. I mean, and I am no expert on Duverges Law, but it's not quite a strict law like Newton's law of gravity, in the sense it's just kind of an observation, and it does hold for the most part for governor's races and legislative races. What I think is interesting about the presidency is so important, both in the power that's being accumulated over time, and also psychologically, it dominates so much of the national attention that you get these, whether they're vanity projects of billionaires, like Howard Schultz thought about it, the Starbucks guy, or Bloomberg thought about being an independent candidate, or you just get these ideological committed parties like the Green Party or the Libertarians. The presidency draws it's a pejorative term, but it's a spoiler effect in a way that down ballot races don't. So it is something of an exception of the Duverges Law that we have the persistence of this spoiler problem in presidential elections. And maybe more than Jesse, I am troubled, I mean, by, again, and this is nonpartisan, it shouldn't be a frustration of the electorate's will either way. But, you know, when Howard Schultz thought about running as an independent, this Starbucks CEO guy, he caused a complete freak out among the Democrats because he thought he would be a spoiler handing the election to Trump. And that people were thinking about that under our system because they recognize how plurality, winner take all operates. But going to a national popular vote compact system, which would be national plurality winners, or if that were just the rule by constitutional amendment without a majority requirement, there ought to be the same freak out because it really shouldn't matter whether Howard Schultz wins Michigan, Wisconsin, and Pennsylvania by, in effect, you know, siphoning votes away from Democrats and splitting the anti-Trump vote that way, or he does it in a national popular vote, causing Trump to win with, you know, whatever, 45% or whatever. Either way, it's sort of a frustration of the will of the electorate. Now, it is true that the closer you get a plurality win to 50%, you know, the higher it is, obviously. You know, 30% is smaller than 45%. But, you know, I'm troubled by, you know, let's say the numbers are 49, 48, and 3. And I'm thinking about Justin Amash here, right? And you can imagine the two-party candidates going 48, you know, 49, 48, 3, where the 3 really makes a difference. In other words, if you had a runoff or you took Amash out of the race, the candidate with 48% would leapfrog and get to 51%. And so, you know, again, that could be Trump, could be Biden, but, you know, I don't think it's democracy, small d, working very well if Trump wins with 49% of the vote because and the anti-Trump vote is split between Biden and Amash, but it would have coalesced to 51% through some form of runoff mechanism. So I think that is something we should feel as something that's a defect of the system and not be, again, oftentimes the candidate with 48 or 49% would have won the runoff. Part of the exegesis that I go through at great length in part 2 of the book is to explain among the 15 races or so that Jesse talked about, which sub 50% winners would have won with runoffs in place anyway. And often that would be the case, but occasionally you'll get these winners who fail from a perspective of majority rule.
So
can I add something there, Steve? Or
I want to let you respond, Jesse, but I also want to inject something for both of you, which is from one of the audience members who, in connection with the issues Ned's just been talking about and you raised earlier, Jesse, has asked the question, well, could we not limit the general election to only 2 candidates? And so I just wanted to invite both of you to think about that as a hypothetical solution as you address the larger question about party candidates.
I mean, that's a larger discussion. I'm a fan of more parties. I'm a fan of proportional representation systems in other countries. So I may not be the best person to speak on that. I think the 2-party system has its strength and it also has its, as we see now, extreme weaknesses. And I'm in favor of more types, a greater range of parties representing a greater range of Americans, especially when you have 330 million people. There's just no way you're going to reflect who people are with any kind of accuracy when you're just boiling it down to 2 major parties. But I just wanted to come back for a second to this issue of proportional allocation because I think it brings up something very deep about people's sense of how we choose the president. And I wanted to, and it also harks back to your earlier question about partisan issues, right? Because this is all so much about partisan disputes. Like we cloak these debates in higher principle, but really, and I think Ned and I are sort of in the minority and actually really feeling like you know, we really do see the principles here, but I think for most people, it's like, what's the best way to get my candidate to win? And, you know, the Senate actually passed an amendment to change the Electoral College to a proportional system, right? It would force all states to use proportional awarding of electors, not winner take all, in 1950. That amendment died in the House. That was one of the more than 700 that I've talked about, but it actually passed the Senate with more than 2/3, you know, the required 2/3 for a constitutional amendment. One of the main advocates of that effort was a House member named Ed Gossett from Texas. In 1951, the year after this passes the Senate and fails in the House, he gives a speech on the House floor. And I just want to read to you a little excerpt of that, because I think it really gets at the heart of what people are so bothered by about winner take all. This is what he says. And I just want to set this up a little bit. Historically, in the mid-20th century, the biggest and most important swing states in the country were northern states like New York and Illinois, right? We don't think of those as swing states today because they're very sort of strongly, they vote in favor of the Democrats. There's still millions of Republicans in them, but they vote for Democrats pretty reliably, so they're not battleground states. They were battleground states in the middle of the 20th century, and the people who swung those states were largely racial and ethnic minorities in the big cities. So Black voters, Jewish voters, they were often the constituencies that could determine which way those states swung and help one party or the other secure the White House. So those votes mattered a lot, and those constituencies mattered a lot. And they knew they did, and they actually defended the Electoral College. Black lawmakers in New York were some of the strongest defenders of the Electoral College in the middle of the 20th century, and for many decades after, because they knew it gave them this extra power. So here's what Ed Gossett says on the floor of the House in 1951, acknowledging that is a reality of the time. Now, please understand, he writes, I have this in my book. Please understand, I have no objection to the Negro in Harlem voting and to his vote being counted. But I do resent the fact that both parties will spend 100 times as much money to get his vote, and that his vote is worth 100 times as much in the scale of national politics as is the vote of a white man in Texas. And then I'll skip a few others here. And then he says, is it fair? Is it honest? Is it democratic? Is it to the best interest of anyone, in fact, to place such a premium on a few thousand labor votes, or Italian votes, or Irish votes, or Negro votes, or Jewish votes, or Polish votes, or communist votes, or big city machine votes, simply because they happen to be located in 2 or 3 large industrial pivotal states? So that's from a conservative in 1951, right? Who is basically making the eloquent case against winner-take-all rules. The whole idea is, when you have this statewide winner-take-all, whole portions of your population are wiped out in the vote for president, because our popular vote for president is not the real vote for president. I think most people may not quite realize that. The vote we hold in November is not the real vote. It's basically an advisory vote. The real vote for president happens when the electors gather in their state capitals in late December. That's the vote for president. And when states send their electors under the winner-take-all rule, they basically erased everyone who didn't vote for the candidate who won the most votes in that state. To me, that's extremely destructive to a representative democracy, because it makes people feel like they don't matter, they don't exist. And that's why I think the Electoral College, as it functions today, is fundamentally incompatible with our democracy.
So let me see if I can ask both of you to talk a little bit about some of the practicalities. I mean, these are now a collection of several questions that have come in. And so, for instance, with respect to Ned's proposal that states not be able to award all of their electoral votes without the candidate having achieved a majority, one way of getting there is ranked choice voting. Another would be to have a runoff. And so one person has asked for a little more of an explanation of how ranked choice voting would work. That's a real practical question for you, Ned. And let me also just tee up for Jesse a couple of similar practical questions. So one is a question of whether Congress would need to approve an interstate compact like the National Popular Vote Plan Interstate Compact. And just for a little more of your own clarification of to what extent you are a supporter of exactly that plan. And then a secondary practical consideration there is, what if the actual counting of the national popular vote is significantly delayed? It often takes a long time for some states, and in the current Electoral College process, typically that hasn't created a real delay in knowing who the president is, but could it in a popular vote plan? So Ned, I'll throw to you the ranked choice explanation, and then Jesse, the practicalities of a national popular vote compact.
Sure, thanks, Steve. And before I get to ranked choice, just a quick second on a previous question about could it be possible to only have 2 candidates on the November ballot? The answer is yes, if there is some preliminary vote, maybe around Labor Day, that gave third parties a shot at in the process. The US Supreme Court in a series of ballot access cases has said you can't have a 2-party duopoly completely. You have to give minor parties and independent candidates some fair shot. But you could modify what California and state of Washington have done with their so-called top 2 system. You could modify that such that the runoff, as it were, was in November, and there would be a preliminary vote, again, September, with Jill Stein and Gary Johnson and Justin Amash. They'd all have a fair chance around Labor Day. And if they were among the top 2, they'd make it to November. But if they weren't, then the November ballot would just be 2 candidates. So that would be consistent both with my principle and with existing Supreme Court jurisprudence. Now, on how ranked choice vote works is a little bit technical, so I won't go into all the details, but voters would get a ballot that would allow them to rank the options. And there's a great children's illustrator who says, you know, imagine just ranking your favorite flavors of ice cream. On the ballot is chocolate, vanilla, strawberry, you know, coffee, whatever. And instead of having to pick one flavor, you just rank your preferences. But the question is, which flavor we're only buying one flavor for our party, so which flavor gets bought? The way the computers work is they'll look and see which of the flavors gets the least number of first place votes. So let's say coffee ice cream doesn't come in first very much, it gets eliminated. With respect to all the voters who preferred coffee ice cream over chocolate, vanilla, and strawberry, because coffee is now eliminated, you look, what were their second choices? And you reallocate those voters to their second choice preferences because you eliminated the first choice. And you can do this successively round after round. That's why it's sometimes called instant runoff voting, until you get a majority winner. So the flavor of ice cream that will be bought for everybody at the party will be the majority choice using the rankings, as opposed to just which flavor was the plurality winners, you know, so to speak. Is that enough of an explanation for how the ranking system would work?
I think that'll work.
Yeah, Steve, can I just step in there for a second?
Yeah, please.
I think Ned just gave a great, I'm a big fan of ranked choice voting, and I think it would solve a whole lot of problems in our democracy, and not just this one. But I just want to add one thing. I think he described it perfectly. But I think one of its biggest benefits is that it eliminates this problem of the spoiler. And the reason that it does that is, right now, people are forced into a binary choice, right? They have to choose one person, right? And some people are just going to feel like, you know, we saw this in 2016. I hate Trump and I hate Hillary, so I'm going to vote for Gary Johnson, or I'm going to vote for Jill Stein. Even though they knew those candidates weren't going to win, it was just their way of registering their anger at the major parties, or a protest vote, or whatever. Maybe a few people actually really wanted those people to be president, but that, you know, that's a small group of people. So what ranked choice voting allows people to do is to actually express those preferences, to say, I don't like the major party candidates, but to do so in a more nuanced way, and to say, yeah, that person isn't my first choice, but if I had to go with, you know, someone other than my first choice, who might be Gary Johnson or Jill Stein, I would pick Hillary Clinton, or I would pick Donald Trump. And what that does is it allows people to express those preferences and yet not undercut the fundamental value of majority or plurality rule that we're talking about here. And you end up nevertheless with a candidate who gets to a majority, not by simple first place votes, but by this agglomeration of first, second, and maybe even third place votes, suggesting that that person has the most broadest support of any of the candidates when you take into account everybody's rankings. And I think it's a really wonderful and sophisticated and thoughtful way of measuring the public's desire for different types of candidates without forcing people into that binary choice.
Great, thanks, Jesse. So how about some of the practicalities of national popular vote? And
sure.
You know, it's
you mean of the compact.
Yeah, of the compact. Thank you. Including
sure.
its enforceability too, as
yes.
well.
Yeah. So for people who don't understand it, I'm going to just explain very quickly what the Popular Vote Compact is. So this effort started about 15 years ago. It was started by a man named John Koza, who's a computer scientist in California, who designed this, what I consider to be a very elegant method of using the Electoral College, not abolishing it, but using it to get to a popularly elected president. How does he do it? By the same mechanism we've been talking about, which is that states themselves decide how to award their electors. They can do anything they want. They can award them by winner take all. They can award them by congressional district. They can reward them by proportional allocation. They can, you know, look at the weather in Cuba today and decide that they're going to base it on that. There's really no limitations other than other constitutional requirements like equal protection and things like that on how the states do this. So what the compact does is states, it's an agreement among states. States that join it, they're basically signing a contract that says, we agree as a state to award all of our state electors to not the winner of our statewide popular vote, but to the winner of the national popular vote. To whichever candidate wins the most votes in the country, we will give that candidate all of our electors. When states, and they agree to do that when states representing 270 electoral votes, which is a majority, which is what you need to become president, join the compact as well. When states representing 270 electors have joined together in this compact, the compact automatically takes effect, and the person who wins the most votes automatically will become the president. They would also win more electors from other states that are not members of the compact, but they would get at least 270. That's I think the sort of elegance of this project. Now the question from the viewer, which is, would Congress need to consent to this, is an interesting question. So in the Constitution, in the sort of black and white language of the Constitution, it says Congress must, I'm not quoting directly, but it says that Congress has to consent to compacts between the states or among the states, right? In practice, that is not true. In practice, the Supreme Court has for more than a century distinguished between two kinds of interstate compacts. Those that in some way infringe on federal power or the sovereignty of the federal government, and those that do not. The vast majority of interstate compacts over things like interstate lottery or water rights, you know, between two states that share a body of water, these do not infringe on federal sovereignty. They do. The Supreme Court has said for more than 100 years, these compacts do not require consent from Congress. Other compacts that infringe on or in any way interfere with federal sovereignty do require consent from Congress. So the question is, does a compact like this that gives these states, in which these states agree to allocate their electors according to the national popular vote, infringe in some way on the power of the federal government? The answer by the people who run this compact is no, it doesn't, because the states have total authority to decide for themselves in the first place how to award their electors. So what federal power are they infringing on? None, because the federal government has no authority to tell states how to award their electors. So I think that's actually a very powerful argument, and I think it's legally quite sustainable. I am not saying that it would necessarily win in this Supreme Court, but I do think that it's a very strong argument. And just to be clear about where the compact is right now, 15 states have now joined the compact along with the District of Columbia, and those states equal 196 electoral votes. You need to get to 270, so they need 74 more to get there. Virginia is right on the edge. It may pass it in the next 6 months or so, which would take them to 209, meaning they would need 61 more. But they are closer to a popular vote. They're closer to getting to the compact taking effect and a popular vote for president than any other mechanism that we've tried in the last 230 years. So I'm all for pushing ahead with it.
So a sort of set of related questions coming out of this, which are, to what extent are electors even obligated to follow whatever their state has told them to do? And of course, the Supreme Court is considering a case that raises exactly that issue now. And depending how that comes out, that might have some implications on the feasibility of popular vote, the National Popular Vote Compact. But underneath that is maybe its own question of the constitutionality of states trying to bind themselves and bind their electors to something that they, as an individual state, wouldn't otherwise have chosen to do. And that's a separate question of whether it's constitutional for the compact to become effective without congressional approval. It's whether there's some other way in which it might be unconstitutional to try to enforce the compact if a state subsequently didn't want to, or a state's electors subsequently didn't want to.
Well, states can always, it's like any contract, right? A state can back out if it chooses down the road that this isn't the way that it wants to do things. There's a blackout period that the compact creates, as all contracts tend to have, is blackout periods in which a party to the contract cannot back out. But between July 20th of the election year and January 20th, which is inauguration day of the following year, which is a 6-month period, states cannot back out then, which is in other words saying you can't game the compact just because you don't like the way it's looking like it might turn out. So in Massachusetts, for example, right, a strongly Democratic state, Massachusetts is a member of the compact. If it was looking in like late summer, let's say the compact was in effect and it was looking in late summer like the Republican candidate was going to win the popular vote in the country just from polling, could Massachusetts back out and say, oh, we're not going to do this because that would force us to give our electors to the Republican and we don't want to do that? No, they couldn't do that. They couldn't back out because they are a member of this compact. But I mean, that's just one answer to that particular question. The faithless electors question is another one which I'm happy to weigh in on, and the Supreme Court is obviously going to weigh in on it in the next few months. But if Ned wants to take that one too, I'm happy to hear.
Well, what I was thinking, I don't want to put you on the spot, Jesse, but I'm having such a great time with this conversation, and I hope our audience has enjoyed it. I'd love to invite you back, either at the time of oral argument or what, and we can continue it and focus on that issue as well. I mean, my thought on the compact is, in addition to the issues that we've talked about so far, which Jesse's handled exactly right, I worry that the Supreme Court will find it unconstitutional just as inconsistent with the spirit of the system, in that it's designed to move from a state-by-state based aggregation of these different sovereigns and what they want into this uniform approach. And again, I would love a constitutional amendment that got us a uniform vote nationwide. But if you're an originalist like Justice Scalia used to be, or maybe Justice Alito is now, and you think that the fundamental original principle here is that states vote separately for their electors, it is a clever end run around the system, but it is sort of a way to put a dagger in the heart of the system, from inside. I mean, it's trying to use the Electoral College to destroy the Electoral College. And you can take two different views on that. You could say, well, framers, you blew it, you wrote it wrong, and this is perfectly okay for the states to do what they're doing because they have the power that Jesse said they had. Or you could say states can use that power up until the point that they destroy the essence of the system itself. And I just don't know which way the Supreme Court would go.
Ned, I mean, doesn't that beg the question a little? I mean, to say that you're using the Electoral College to destroy the Electoral College assumes that the Electoral College, the essence of the college, is something that we can divine and that it is something that we've agreed on. And yet, to say that it would violate the spirit of the system, this is like sort of the most anti-originalist approach we could take, right? Like I don't think the originalists on the court are generally concerned with what the spirit of something is. They're concerned with what it says in the document and what that meant to the founders. And when you go back and look at that, I feel like the founders weren't particularly concerned with this being a state-by-state process. As soon as they started to see how it played out in practice, many of the top ones, including Madison, James Wilson, Thomas Jefferson, all were calling for a popular vote for president. They didn't like the way the system was playing out. And I think it's just, the reason I think it's question begging is that it suggests that something about the college is essential. And as we've been talking about, nothing about the way the college operates today is in the Constitution itself. It's really just a function of how states choose to do this. And as you pointed out earlier, I think very helpfully, the reason states choose winner take all is because it helps them as states get their political clout. And if this is what helps states, the states that are currently not battleground states don't have political clout right now because they adopted a system 100 or 200 years ago that currently doesn't work for them because the candidates don't care about them anymore. So if this is their way of saying, we're going to regain some of our political clout by adopting a measure in which we look at the popular vote nationwide, I guess I just don't see why that's any more a violation of the essence of what the Electoral College was designed to be than what it is today.
Yeah, just real quick. I mean, I'm not saying that I would rule that way, but my fear, just as a practical matter, is that all this effort's going to be put by the compact. As you say, we're not at 270 yet, and we're not going to get there by this fall, and maybe by 2024. But it's been around since 2000. It's gained some momentum for sure, but and then so even if you cross the line of getting to the magic number of 270, it could get tripped up at the Supreme Court.
No question.
Whereas the ranked choice voting idea, yes, there's no argument there. I mean, because again, each state can do it on its own. If only Florida had adopted it before 2000, you wouldn't have to worry about hanging chads because Ralph Nader wouldn't have been a spoiler. So it's a more practically, it's more bang for the buck immediately. And so
I'm completely with you there. I'm completely with you on that. That I'm not taking any bets on how the Supreme Court does this. I'll just say though, on the faithless electors question, this was the one that Steve mentioned a few minutes ago, which is, can states bind their electors? Can states tell their electors how to vote? And more to the point, what the Supreme Court is deciding is, can states punish their electors who don't vote the way that they have been pledged to vote, or can they replace them with electors who do that? The reason the Supreme Court took this case is that several electors did this in 2016, and states dealt with it differently. In Colorado, a Democratic elector named Michael Baca, whose story opens my book, I tell the story of how these electors tried to keep Donald Trump out of the White House by being faithless in 2016. Michael Baca did not vote for Hillary Clinton. He was a Democratic elector. He did not vote for Hillary Clinton. He voted for John Kasich, your former governor, who was at the time considered to be a moderate and more fit and more capable option for Republicans than Donald Trump. He was removed as an elector and replaced with someone who had voted for Hillary Clinton. He sued, and he ended up winning in the federal court of appeal, in the federal district court, and then the federal court of appeals in Colorado, on the grounds that he, under the original understanding of how the Electoral College worked, he should have complete independence in how he cast his vote. Another Democratic elector in Washington State did the same thing. His vote was actually counted, but he was fined $1,000 for doing so, for breaking with faith and for going against Hillary Clinton, whom he'd pledged to vote for. And he also sued. And in that case, he lost, and the state Supreme Court said, states absolutely can tell electors how to vote, and they can remove them if they want. This is entirely in the state's power under the Constitution to do this. So the fact that we have these two competing decisions is why the Supreme Court took it. That's why the Supreme Court exists in part, is to resolve, laws that are unequally applied around the country. So the Supreme Court is taking the case. I'm going to give you like the TLDR version, which is, it really doesn't matter how the court rules in this case. It's not going to make a big difference whether or not we have the National Popular Vote Interstate Compact or not. The vast, vast majority of electors in the history of the country and today vote for the candidate of the party that they are pledged to. Now, this is something else that people may not understand about the Electoral College. States don't have a single body of electors who are just waiting, to hear the oracular, determination of the voters in that state to vote how the voters tell them to vote. Each candidate comes in with their own slate of electors. So Hillary Clinton has 29 electors in Florida. They're Democratic electors. Donald Trump had 29 Republican electors in Florida. Whichever candidate wins the statewide popular vote sends all of those electors to the state capitol to vote. In other words, the electors want to vote for their candidate. That's why they're there. They were chosen because they are reliable partisans. All right. So and the way the popular vote compact works is it sends the slate of the winning candidate in the national popular vote to the state house to cast their ballots. So again, it's the same thing. Candidates, the electors want to vote for their candidate. It would be really hard to see a scenario in which large number of electors decided, oh, I'm just going to go with my heart. Their heart is with their candidate. Consider 2000, right? It was a 4-vote difference at the end of election night. It was 271 to 267. That once Florida was, if you give Florida to George W. Bush, he was winning 261 to 267. That's 4 votes. In other words, a switch of just 2 electors in the entire country would have kept George Bush from waltzing into the Oval Office. Nobody changed. The only elector who went faithless in 2000 was a Democratic elector in the District of Columbia who was protesting the fact that the DC has no congressional representation. So Al Gore was actually the one candidate who lost a single elector in that election. In other words, even in conditions where we're talking about an extremely close electoral vote where 1 or 2 people could literally hold the future of the nation in his or her hands, they don't do it.
Well, I'm sorry that we're going to have to wrap it up at this point. We've got so much more we could keep discussing, and I'm sorry that there are some nice questions out there, including whether ranked choice voting and runoff voting ends up disadvantaging third parties and even sometimes promoting more extreme responses as a result of the third parties not having a real voice anymore. But and questions also about an actual constitutional amendment and prospects for that, which is different from what both Jesse and Ned are talking about. They're trying to come up with some solutions that might be much more achievable than a true amendment here. So thank you both, Jesse and Ned, for this very stimulating and timely discussion. As I mentioned, for anyone who wants to pursue these issues further, we invite you to check out Jesse's and Ned's new books, and we will now put the web links for their publishers into the chat portion of this webinar. And they're also on the Election Law at Moritz webpage. And so you can find them in either place. And before we go, let me make also a brief announcement about another upcoming Election Law at Moritz program. On May 4th, Election Law at Moritz will be hosting an event that we've titled, What If the 2020 Presidential Election is Disputed? An Expert Roundtable. And that event, which will also be using a webinar format, will bring together about 24 legal scholars and other election administration experts to engage in a series of 3 roughly 90-minute discussions about potential issues that could arise and require resolution after November 3rd. That is, between the time of Election Day and Inauguration Day, what might still go wrong and require some sort of resolution. So watch our Election Law webpage for further details on that. And now let me again thank both Jesse and Ned, as well as the IT team at the College of Law for its assistance with today's webinar, and especially Jillian Thompson, the Election Law at Moritz program assistant, for a terrific amount of help with the logistics and preparation for this event. And finally, thank you to everyone who joined us today in this online world. And if you'd like to share this event with others who couldn't join us or see parts of it again yourself, we've been recording it, and we will plan to post the recording of it to our Election Law at Moritz webpage once we've been able to complete the post-production work, which is going to take a few days at least. So at some point soon, we'll have it up there. And with that, again, just thanks to everybody. Be well. We look forward to seeing you all again soon and in person as soon as we can.
Thanks.
Thanks, Ned.
Thank you. Thanks, Jesse.
Thank you.